Now, I will discuss this very important topic of jurisdiction. Jurisdiction is defined as the power and authority of a court to hear, try, and decide a case. Okay? Jurisdiction is the court's authority to hear and determine a case or a cause or the right to act in a case. The power to control the execution of a decision is also an essential aspect of jurisdiction. 4 concepts of jurisdiction. Jurisdiction over the subject matter or the nature of the action. Jurisdiction over the person of the parties. Jurisdiction over the issues of the case. And in cases involving property, jurisdiction over the res or the thing which is the subject of the litigation. Courts exercise the powers conferred on them with binding effect if they acquire jurisdiction. Let us illustrate. An action or proceeding is commenced by the filing of the complaint or other initiatory pleading. By that act, the jurisdiction of the court over the subject matter or nature of the action or proceeding is invoked or called into activity, and it is thus that the court acquires jurisdiction over said subject matter or nature of the action. And it is by that self-same act of the plaintiff or petitioner of filing the complaint or other appropriate pleading, by which he signifies his submission to the court's power and authority, that jurisdiction is acquired by the court over his person. On the other hand, jurisdiction over the person of the defendant is obtained by the service of summons or other coercive process upon him or by his voluntary submission to the authority of the court. Jurisdiction over the res is acquired either by the seizure of the property under legal process, whereby it is brought into actual custody of the law, or as a result of the institution of legal proceedings in which the power of the court is recognized and made effective. The seizure of property under legal process contemplated in the foregoing partakes of a writ of preliminary attachment as provided in Section 1, Rule 57 of the Rules of Court. Jurisdiction over the issues of the case is determined and conferred by the pleadings filed in the case by the parties, or by their agreement in a pretrial order or stipulation, or at times by their implied consent, as by the failure of a party to object to evidence on an issue not covered by the pleadings as provided in Section 5 of Rule 10 of the Rules of Civil Procedure.